Good day to everyone. We are going to discuss the latest jurisprudence on the crime of bigamy. I am talking about the recent Supreme Court case of Luisito G. Pulido versus People of the Philippines. This was decided en banc by the Supreme Court on July 27, 2021. Here are the facts of the case. Luisito married Nora. Subsequently, Luisito contracted a second marriage with another woman named Rowena without having his first marriage with Nora legally dissolved. Feeling betrayed, Nora filed a complaint for bigamy against Luisito. Luisito, however, claimed that his marriage with Nora was void because of the absence of a marriage license. The RTC of Las Piñas nonetheless convicted Luisito of bigamy since there was no prior judicial declaration of nullity of his marriage with Nora at the time he married Rowena. On appeal, the Court of Appeals affirmed Luisito's conviction, so he elevated the case to the Supreme Court. It was while the case was pending in the Supreme Court that the RTC of Imus, Cavite entered a decision declaring Luisito's marriage with Nora as void due to the absence of a marriage license. The judicial declaration of the nullity of Luisito's first marriage with Nora was secured only after Luisito contracted a subsequent marriage with Rowena. Luisito interposed the defense that the subsequent judicial declaration of nullity of his first marriage should exculpate him from criminal liability for bigamy. The issue, therefore, is whether a judicial declaration of nullity of the first marriage secured after the celebration of the second marriage can be considered a valid defense in the crime of bigamy. Before I discuss to you the decision of the Supreme Court, let us first take note that the prevailing case law prior to this Pulido case was that a person must first secure a final judicial declaration of nullity of his or her previous marriage before he or she can contract a subsequent marriage. Otherwise, the subsequent marriage will be considered bigamous. This case law was based on Article 40 of the Family Code, which states that, and I quote, "The absolute nullity of a previous marriage may be invoked for purposes of remarriage on the basis solely of a final judgment declaring such previous marriage void." The rationale for this case law based on Article 40 was that even if the marriage is void, a final judgment declaring it void for purposes of remarriage is required. Parties to a marriage, according to the Supreme Court at that time, should not be permitted to judge for themselves its nullity. Hence, a court action declaring its nullity is needed. Now, what was the decision of the Supreme Court in the Pulido case? Did the Supreme Court maintain this case law in the case of Luisito? The answer is no. The Supreme Court ruled in Pulido versus People that in criminal prosecutions for bigamy, the accused can validly interpose the defense of a void ab initio marriage even without obtaining a judicial declaration of absolute nullity. Consequently, a judicial declaration of absolute nullity of the first marriage obtained by the accused in a separate proceeding, irrespective of the time within which it is secured, is a valid defense in the criminal prosecution for bigamy. What this means is the accused in a bigamy case is not required to obtain a judicial declaration of absolute nullity of a void ab initio first marriage in order to raise it as a defense in a bigamy case. In other words, the accused can collaterally attack the nullity of his or her first marriage in the criminal case for bigamy. He or she may present testimonial or documentary evidence such as, for example, the certification of the local civil registrar as to the absence of a marriage license, or the birth certificate showing that he or she was below 18 years of age at the time of the first marriage. This will be enough to put reasonable doubt on the guilt of the accused, which can then lead to his or her acquittal. But if the accused is later able to obtain a final judicial declaration of absolute nullity of his or her first marriage, then so much the better. And this is so even if he or she obtained the same only after contracting the second marriage. He or she can raise this as a defense in a criminal prosecution for bigamy. The reason for this is that the effect of a marriage that is legally dissolved for being void is that it is inexistent from the very beginning. It is as if no marriage had taken place. If there was no such first marriage, then there is no bigamy to speak of. For example, X married Y. Thereafter, X filed a petition for declaration of nullity of his marriage with Y on the ground of absence of legal capacity. Like for example, X was below 18 at the time of his marriage with Y. Now, while this petition was pending, X contracted a second marriage with Z. Enraged, Y then filed a criminal complaint for bigamy against X. Subsequently, the fiscal filed an information for bigamy against X in court. If you were the judge, how will you decide the case? Prior to the Pulido case, X would have been guilty of bigamy because he contracted a second marriage before his first marriage was legally dissolved. A prior judicial declaration of the absolute nullity of his first marriage is required before he could enter into a subsequent or second marriage. Now, in light of the Pulido case, even without such judicial declaration, X can now collaterally attack the validity of his first marriage with Y by presenting testimonial and or documentary evidence that he was below 18 years of age when he married Y. X will be acquitted based on reasonable doubt. Suppose X, during the pendency of the bigamy case, is able to obtain a final decree of absolute nullity of his marriage with Y. Can he use it as a defense? Now, prior to the Pulido case, since X proceeded with the second marriage without his first marriage being legally dissolved, he would have been guilty of bigamy, regardless of a subsequent declaration of the nullity of his first marriage. He therefore could not use it as a defense. But in light of the Pulido case, X can now use it as a defense. This is so because a judicial declaration of absolute nullity of the first marriage obtained by the accused in a separate proceeding, irrespective of the time within which it was secured, is a valid defense in the criminal prosecution for bigamy. Another question. Suppose X files a motion to suspend the criminal action for bigamy on the ground that the previously instituted petition for nullity of his marriage presented a prejudicial question. will such motion be granted? Prior to the Pulido case, the said petition would not pose a prejudicial question because X could still be convicted of bigamy even if his first marriage with Y would later be nullified. But in light of the Pulido case, such petition will now pose a prejudicial question because if his first marriage is nullified, he will not be liable for bigamy. The resolution of the issue of whether X's first marriage with Y is valid is determinative of whether the criminal case for bigamy will proceed. Hence, the motion should be granted. Does the ruling in Pulido apply to voidable marriages? The answer is no. If the first marriage is merely voidable, such marriage must be legally dissolved first before a person will enter into a second marriage. This is so because a voidable marriage is still a valid marriage until and unless the same is annulled or legally dissolved. A person wanting to remarry must first secure an annulment decree before contracting a second marriage. Otherwise, such person will be liable for bigamy since the voidable first marriage is considered valid and subsisting when the second marriage was celebrated. Also take note that the ruling in Pulido applies to both the first and second marriages. For example, X married Y. Later, X married Z. X's marriage to Z, however, was contracted without a marriage license. Charged with bigamy, X now interposes the defense that his marriage with Z is void because the same was contracted without a marriage license. Question: is X correct? The answer is yes. For bigamy to exist, the second marriage must have all the essential requisites for validity, were it not for the existence of the first marriage. In other words, the second marriage would have been valid had there been no valid and subsisting first marriage. If the second marriage is by itself void, then there is no bigamy. Hence, X can collaterally attack the validity of his second marriage by presenting evidence of the absence of a marriage license, like for example a certification from the civil registrar that no marriage license was obtained by X and Z. What then are the elements of bigamy? First element, that the offender has been legally married. Second, that the voidable marriage has not been annulled or legally dissolved, or in case his or her spouse is absent, the absent spouse could not yet be presumed dead according to the civil code. Third, that the offender contracts a second or subsequent marriage. And fourth, that the second or subsequent marriage has all the essential requisites for validity, were it not for the existence of the first marriage. We will now attempt to discuss each of these elements. Let's go back to the first element, that the offender has been legally married. This refers to the first marriage of the offender. This does not merely refer to the act of marriage. The marriage itself must be valid, or at least voidable. A voidable marriage is still a valid marriage unless annulled or legally dissolved. A marriage is valid if it complies with Articles 2 and 3 in relation to Article 4 of the Family Code. Now, I will not anymore discuss to you each of the requisites of a valid marriage as found in the Family Code. You will have to review that for yourselves. Voidable marriages, on the other hand, are those enumerated in Article 45, also of the Family Code. The first marriage must be valid or at least voidable. It must not be void. Otherwise, there would be no bigamy to speak of, because in a void marriage, it is as if no marriage has taken place. On the other hand, void marriages are those enumerated in Articles 35, 36, 37, and 38, also of the Family Code. Let's go to the second element, that the voidable marriage has not been annulled or legally dissolved, or in case his or her spouse is absent, the absent spouse could not yet be presumed dead according to the Civil Code. This second element, take note of this, applies only to a voidable marriage, because as already discussed in the Pulido case, there is no necessity of securing a judicial declaration of the nullity of a void ab initio first marriage for purposes of bigamy. To repeat, the accused can validly interpose the defense of a void ab initio marriage in the same criminal proceeding for bigamy, even without obtaining a judicial declaration of absolute nullity. Under Article 41 of the Family Code, a summary proceeding for the declaration of presumptive death of the absent spouse is required before the surviving spouse can marry another. The third element is that the offender contracts a second or subsequent marriage. And the fourth element is that the second or subsequent marriage has all the essential requisites for validity, were it not for the existence of the first marriage. Now, as already discussed, the second marriage must have all the requisites for validity, were it not for the existence of the first marriage. In other words, the second marriage would have been valid had there been no valid and subsisting first marriage. If the second marriage is by itself void, meaning there are other grounds that make the same void other than by the fact that it is bigamous, then there is no bigamy. For example, X married Y. While the first marriage was still valid and subsisting, X married Z, who was 17 years old at the time of the second marriage. Here, there is no bigamy because the second marriage is by itself void.